Ever heard someone say, "You can't trademark that?" and thought, really? Why not? Well, some people actually tried. From a university trying to own the word "the" to a celebrity who forgot to sign her own application. Today, we're diving into the 5 most controversial, dramatic, and downright ridiculous trademark fails ever filed. Each of these stories has one thing in common. They show what happens when you misunderstand how trademarks actually work. Imagine walking into court and saying, "Your Honor, I'd like to trademark the smell of strawberries." That's exactly what a French company called Eden Sarl tried to do. They wanted exclusive rights to the scent of fresh strawberries, not for food, but for things like soaps, stationery, and clothing. Sounds sweet, right? But the EUYPO said, "No, monsieur." Why? Because smells are subjective and impossible to define precisely. What kind of strawberries? From which region? What ripeness level? Trademark law requires something specific that can be represented clearly. And smells, well, don't exactly fit into that box. Now contrast that with Hasbro, the company behind Play-Doh. In 2018, they successfully trademarked the distinctive scent of Play-Doh. Yes, an actual smell trademark that worked. How? Because Play-Doh's scent wasn't just sweet or pleasant. Hasbro described it in precise, measurable terms. A sweet, slightly musky vanilla fragrance with slight overtones of cherry, combined with the smell of a salted wheat-based dough. That level of specificity convinced the USPTO that the scent was distinctive, consistent, and instantly associated with Play-Doh, unlike the vague, undefinable smell of strawberries. So, the strawberry smell trademark was tossed out, and it's still cited today as one of the strangest trademark attempts ever made. You think that was weird? Wait till you hear this one. In 2019, Ohio State University tried to trademark the word "the." Yes, literally the most common word in English. They wanted to protect it for use on their apparel, as in the Ohio State University. The internet exploded, memes everywhere. People were asking if we'd now need to pay royalties every time we said "the." Legally, though, the USPTO wasn't laughing. They rejected the filing at first, calling it merely ornamental and not distinctive. And while OSU eventually got a limited version of it approved for specific stylized logos, it became a textbook example of how trying to own common words can backfire hard. This next one takes trademark overconfidence to a new level. Harley-Davidson wanted to own a sound. Not their logo, not their slogan, the sound of their V-twin engine. They filed for a sound trademark back in 1994, arguing that no other motorcycle in the world roared quite like a Harley. But then came a parade of opposition. Other motorcycle makers filed objections, saying their bikes made similar sounds. After 6 years of legal noise and millions spent, Harley eventually withdrew the application. Lesson learned, you can trademark sounds, but only if they're distinct and consistent, like the NBC chimes or the MGM lion roar. Okay, but imagine trying to trademark your own first name and someone else says, "Sorry, I was here first." In 2015, Kylie Jenner decided she wanted to trademark the name Kylie. The problem is, the name Kylie was already famously attached to another Kylie, Kylie Minogue, the Australian pop icon. Minogue's legal team fired back fast, calling Jenner a secondary reality TV personality and arguing that Minogue had been Kylie long before. The U.S. Patent and Trademark Office agreed, rejecting Jenner's application. This case wasn't just about ego. It highlighted a key trademark rule. Fame doesn't override prior use. Even billionaires and reality stars can't trademark something someone else is already known for. Think that's embarrassing? The next one might be the most avoidable fail on this list. In 2011, politician Sarah Palin tried to trademark her own name for motivational speaking services. Simple, right? Except she forgot one tiny thing: to sign the application. The USPTO rejected it on that technicality, and later because she didn't show enough proof of use for the services she claimed. That's like trying to lock in your Netflix password and forgetting to click save. Embarrassing and very public. It became a meme-worthy moment and a reminder that even public figures can fail a filing if they don't follow the rules. So what do all these trademark fails have in common? They weren't just bad ideas, they were bad filings. And here's the truth. A single mistake like that can cost you your brand, your rights, or your reputation. That's why smart entrepreneurs don't DIY their trademarks. They do it the right way with experts who guarantee results. I'm talking about Trademark Factory, the only firm that offers a 100% money-back guarantee for most trademarks with a simple flat fee and done-for-you service from search to registration. If you've got a brand worth protecting, don't let it end up in the trademark graveyard. Visit trademarkfactory.com today and make sure your idea doesn't become the next viral trademark fail.